Hello, welcome to the Oxford Law Faculty Virtual Open Day. My name's Susan Bright. I'm a professor in the Law Faculty and I'm also a fellow who teaches at New College here in Oxford. And I've been asked if I'll give you a taste lecture. So what I wanted to do in this lecture is three things really. One is just to introduce you to an area where I've been doing quite a bit of research on in the last few years, but then to use it as a way of trying to illustrate to you the number of areas of law that there are that can be looked at within a law degree, and then more particularly to introduce you further to the idea that if you're studying law you have to understand not just the big picture, but also you have to really focus on some details and pay great attention to wording that's used in the context of statutes that you may have to look at and read, or in the context that we'll be looking at, the wording that can be found in contractual documents. So areas of law that you may well be familiar with already include criminal law. We see criminal law all the time in the media and on the dramas we watch on streaming mechanisms and so on, Netflix, Prime and so on. Another area of law that you may be quite familiar with because of debates in recent years is constitutional law, and constitutional law came to the fore in the debates in relation to Brexit, where it raised the issue of the separation of powers, so looking at the balance of the relationship between the executive, the government, the legislature, the parliament, the body that passes and enacts our laws, and then the judiciary, the courts that have to resolve disputes. What we're going to be looking at today isn't either of these areas. But let me make a start by telling you a bit about Grenfell itself. So the Grenfell fire was now more than 3 years ago. It was the 14th of June 2017, and in that fire 72 people died. Fairly soon after the fire itself happened, it became apparent that the reason why the fire spread so quickly was because of the cladding that was on the outside of the building, and this had been put on during a very recent refurbishment project that was carried on. Since Grenfell, obviously there was then a review of other buildings to see if they had the same kind of cladding on, and yes, it turns out that almost 500 high-rise residential buildings have the same cladding as Grenfell had, and this presented and does present a very serious risk of another tragedy happening. Some of those buildings have since had the cladding removed and replaced, but for more than 300 of them that cladding is still to be replaced. But in the course of investigating this, what has further emerged is the fact that there are a large number of other fire safety problems with some of these buildings. So some buildings have a different form of cladding on, not what I'm going to refer to as the Grenfell style cladding, but other cladding, and it turns out that is also unsafe and performs really badly in the event of a fire. Another thing that has emerged is that often what they refer to as fire compartmentation has not been put in correctly, if at all. And fire compartmentation is to do with the idea that when you put up a building, you create a barrier between the different floors. So if a fire breaks out in one flat, it won't spread to the floor above. So if there is a fire, people in the floor above and below can stay where they are, and only the floor affected by the fire has to evacuate. What's now apparent is that for a lot of buildings that fire compartmentation is not effective because it wasn't put in correctly. We don't have reliable data on just how many buildings are affected by this, but it's thought that something like 2,000 buildings are now discovered to be unsafe because of these fire safety issues. So this then brings us to the questions I want to look at today, is what areas of law might this involve? And the first one, this is a slide that was I meant to put up last time, talking about there being a dog's breakfast. And what this is about is where people take the cladding off a building and they discover that actually it's not just a problem with the cladding, but there are all sorts of other problems that are going on behind as well. Anyway, let's skip on to the next slide, which is the one I meant to take us to, the idea that law has a regulatory function. So this is the idea that laws are in part passed to guide and restrain the way in which we behave. So, for example, you'll be pleased to know we have food safety laws, so that when you go and buy a ready meal from the shop or a sandwich, we can be confident that they're going to be safe to eat, because we have laws that regulate the standards that they must satisfy. And we have similar things for buildings. So when a developer puts up a building, they have to ensure that it complies with certain safety standards. And in addition to that, we have building inspectors that go and check that the building has been constructed as it should have been. Now, what is absolutely clear post-Grenfell is that our regulatory system has failed. We can't have so many buildings that are not safe and say we've got a good regulatory system. So there have been massive failures with this system of regulation. But then I want to look at perhaps what can individuals do about it. And this is where I want to break down another area of law to look at how it breaks up into different sort of subtopics, let's call them that. So the area of law we're going to look at now is private law, and private law is to do with a relationship between two private individuals, not necessarily human beings, but they could be between two corporate bodies. So it's looking at the relationship between two private legal bodies. So it could be you and me, or it could be a major corporate body in relation to an individual citizen, or a major corporate body in relation to another corporate body. And we break down private law into further categories. And these we refer to as contract law, tort law, and property law. And contract law is to do with there being an agreement between parties, between private parties. You'll have entered into many contracts, even though you may not have thought of those that in those terms. When you go and buy a drink in a shop, you'll be offering to pay for it. You'll be entering into a contract for the sale of the drink and the purchase of the drink with the shop seller. Tort law is to do with where a wrong has been committed against a private individual. So if I'm out walking down the road and someone's cycling in a rather careless way and they ride into me and cause me an injury, they'll have committed a tort against me, and I may be able to claim damages from them for that tort. And then the final area that I want to talk about is property law. And this is the bit that I'm now just going to open up a little bit more. It's one of the main areas in which I work and I teach. So let's start by looking at this slide. It's a little bit complicated, but what I want to use it for is to show you how a block of flats is typically owned. So if you look at the picture here, we've got this building that is divided up into individual units, which we can call flats. And in the centre of the building, we've got a lift shaft and a staircase. And then outside the building, we've got the landscaping, the tree that's shown here. And underneath, we've got a car park. And in terms of how this would be set up in England, we would have the building is owned by someone who we call a freeholder or a landlord. So the building as a whole will be owned by the freeholder, and the freeholder will sell the individual units or flats to the flat owners on what we call a long lease. This would be a contract giving them the right to use the flat for a very long period of time, and typically that long period of time will be 99, 125 or 999 years. But what the individual's buying is just that flat, just that rectangle. They're not buying an interest in the whole building. And so the building owner, the freeholder, remains responsible for looking after the whole building, the stairs, the lifts, the car parks and so on, and will charge the cost of doing that to the individual unit owners. So each unit owner, each flat owner, who we refer to as a leaseholder because they hold a lease of the flat, will have to pay a service charge towards the costs of looking after the building. Now, what I want you to imagine is that you are a flat owner in one of these buildings. You bought a flat and it turns out that it's got a fire safety problem that needs to be fixed, and it's going to be really expensive to fix. The question that we're going to look at now is, can the building owner, the freeholder, charge you and the other flat owners the cost of fixing the building? So this is the question. If the building is fixed, do the flat owners have to pay towards it? So imagine that in this lease agreement there is this provision. It says that you, the leaseholder, have to pay towards the repair, maintenance and decoration of the main structure of the building. Okay, repair, maintenance and decoration of the main structure of the building. So what I want you just to think about for a minute is, would this cover, do you think, cost of replacing cladding that is defective, or the cost of putting in fire compartmentation into the building? Okay, now hopefully you've got a preliminary view towards that. What I'm now going to do is give you an extract from a law report. So in England, our laws are made up of a mix of statutes, legislation that's passed by Parliament, but also what we call common law that's been developed through the courts over the years. And we learn what the common law is by looking at our law reports. So what I'm about to put up on the screen is an extract from a law report that explains what the word repair means. So let's have a look at this. It's cut from a case called Janet Rager International Limited against Tiri Limited from 2006. And it reads, a landlord's obligation to repair arises when the subject matter of the covenant has deteriorated from a previous condition so that it has fallen below the standard which a reasonably minded tenant would expect under the lease. It will only be in a state of disrepair if one can point to a previous time at which the subject matter of the covenant was in a better condition, so that one can say there has been deterioration. So just stop and have a look through that and see whether that changes your initial thought about whether the flat owner would have to pay towards the costs. Okay, so you'll see that the wording is that there's got to have been a deterioration from a previous condition in order for there to be a repairing issue. And the problem with the cladding cases or the fire compartmentation issue is that there hasn't necessarily been any deterioration. The problem is that it was always faulty from day one. It was put in faulty. It hasn't deteriorated. And so there are real question marks about whether a repair covenant would impose a liability to pay for it. Now, as it happens, I'm using it as an example to show how you have to look so carefully at the wording of contract terms and look at the case law, the law reports, to work out how courts have interpreted those terms. But in practice, if we go back to the problem of Grenfell and the cladding issue, leases will have a whole range of other clauses in them, as well as the one I put up on the screen earlier. And in these other clauses, it is almost always going to be the case that the flat owner, the leaseholder, will end up having to pay towards the repairs. So if that's the case, is there anything that the flat owner can do about it? Can they perhaps recover the cost from the people who were responsible for the problem in the first place? Well, who was responsible? You may say, well, it was the government, because the government had the building regulations and these buildings were not built in a safe way. Or you may say, it was the developer. It was the architect. It was somebody else who designed it and chose to use these materials that made the building unsafe. They are responsible. Yes, well, they may well be morally responsible. The question is, are they legally responsible? And indeed, there are laws, which we haven't got time to go into now, that mean that probably many of these parties are responsible. But bringing an action against them, bringing a legal claim to recover the cost from them, is not going to be easy. And one of the very big problems that individuals face is what we call our limitation periods. And these work on the basis that if you're going to sue someone, you have to do so reasonably quickly. I can't have the cyclist knock into me today and then in 50 years' time try and bring an action against them. So we have a period of time within which it's reasonable to bring action against someone, and that period of time is typically 6 years. That's our limitation period. Now, the difficulty for these buildings is that many of them were put up more than 6 years ago. And so by the time the people living in the blocks discover there's a problem, they are already timed out, so to speak, because of the limitation periods. So this is one of many problems that there will be in holding people responsible for the costs of the repair. Another area of law that I haven't yet mentioned specifically is public law, and this is to do with the relationship between the private individual and the state. And again, it may be sometimes possible for private individuals to bring an action against the state, to hold them to account. And in this context, the most obvious area of law to be looking at is the human rights legislation. And what we see on this slide is 3 of the human rights that possibly might be involved in this kind of context. One is Article 8, which involves, you'll see, the right to respect for private and family life and home. Then if we go to the bottom of the screen, we see Article 1, Protocol 1, which is a right to peaceful enjoyment of possessions. But the most likely one to be of use is Article 2, which is that everyone has a right to life which shall be protected by law. So the state is under a duty to protect every citizen's right to life, and there may well be an argument that they have failed in this context. And if you want to find out more about that article, you might want to look at the blog that I've written, which indeed links to a much fuller article, which is on the Law Faculty website. So if you're interested, there's a blog called Housing After Grenfell, and one of the blog posts I put on there is this one here called Human Rights and State Accountability for Fire Safety in Blocks of Flats. But just to, although we make a strong argument in that article that we think the state is responsible, again, it's going to be really difficult to pursue a claim because of the difficulties in bringing litigation, but also because the argument is actually also quite a difficult argument. But the final area of law I just want to touch on very briefly, because it's not what I cover, and it's also not something that is going to help the individual living in a block of flats, but I just want to flag it up, is criminal law. So we talked about this right at the beginning of the lecture. And criminal law is obviously where the state brings an action against a private person for infringing some code, some rule that we have. The rule may come from statute, or it may just come from the common law. And indeed there has been talk about there being possible criminal charges being brought in relation to Grenfell Tower itself, but the current position of the police is that they can't bring, or they won't bring, any charges until the Grenfell inquiry is complete. And you may know that there has been a big inquiry underway in relation to what went wrong with Grenfell itself, and the phase 1 of the inquiry reported at the end of last year. Phase 2 of the inquiry got going at the beginning of this year, but that had to be paused when COVID made it impossible to continue to hold the hearings. So that hopefully is going to be resumed later this summer. So thank you very much for listening to me. I hope that's given you an overview of the sort of things that you'll be looking at in a law degree, the different topics, but also a particular way in which you might have to look at questions. So the example from the lease is to show you that not just you've got to get an idea of broadly what's going on, but sometimes you have to look at very particular things in order to puzzle through whether or not they are covered by the situation. So thank you very much for listening to me today. Thank you.